Someone's doing it. Awesome. Thank
I
you.
think it was me, but others might want to be a backup. I don't know.
I'll say
Two
a
people
prayer.
can do it.
You drinking a beer there?
Mm-mm.
A
I have
Pilsner?
this vitamin enhanced flavor water,
Got it.
and it's orange vanilla, and it's really good, like a creamsicle. Beer is for later, though.
It's afternoon for you guys.
It is. All right, I'm gonna make everyone come on video, especially you, Jen. Hi, Shannon. Kathy.
Hey, I'm just staying off camera. Looking forward to this, Julian.
Judy said she's coming.
Yeah, I think we can go and get started with introductions, I guess. Am I facilitating? Maybe I'm supposed to be
I think
facilitating.
they told me to do it. I can just
Okay.
dive in. Yeah, so I'm Julian Gross. I'm an attorney based in California. Worked on CBAs for a long time. Long enough anyway to have a bunch of thoughts about things that sort of approaches I've developed or what seem to be useful in representing community coalitions, especially for me as someone who doesn't live in the communities that I'm working with very often or ever, really. I guess some attorneys who've been practicing for a while use these kind of panels as an opportunity to drone on and on as if they have all the answers. I'm not going to pass that opportunity up. So I'll be doing that for some portion of this, maybe at the beginning, with some PowerPoint slides. I'm going to try to go through them really quick. I mean, I think this is a small group and we could probably have a really useful discussion. And I don't know too much about what you guys are doing over in Appalachia. So I would like to hear more about that and have this be as helpful and participatory a session as we can. So I do want to do intros and hear what you all where you all work and if you're working on CBAs or if you've done one already or just thinking about it. Can I ask Amanda how much time do we really have? Like what's our cutoff here?
Let me look at where's it's supposed to be. Technically, it's 1:30.
Okay, so that's 45 minutes or so, a little more than that.
Right.
Cool. Okay, well, that's even more of a reason for me to not talk for too long. So let's do the rest of the intros, just, not just naming where you work, but maybe at least a little about why you're here, or what you're working on, or want to work on related to CBAs. I will throw it to Shea Judy, just because.
I work with Julian. I'm an attorney in San Francisco. Been working with Julian on CBAs for the last couple of years now, and then other matters too. A lot of other racial and economic justice policy support. Yeah, so I'm just here to learn more from Julian as I do every day, and I'll pass it to Elizabeth.
Thank you. My name is Elizabeth Ross, and I'm a summer legal intern with Fair Shake Environmental Legal Services based out of Pittsburgh. And I really don't know that much about CBAs at all. I'm just starting, but I would love to learn more, and I'm excited.
You'll be ahead of the curve. You can make this your practice.
Yeah.
I'm Amanda Woodrum, co-director, and one of Jillian's biggest fans. I'm gonna call on Jim.
I figured you would call on me. My name's Jim Kuhns. I'm the administrator of the Pennsylvania Foundation for Fair Contracting. I have the great privilege of not being an attorney. I just get to pay one a lot of money, but work very closely with the building trades and legal groups, more on the responsible bidder, responsible contractor ordinance part. That's sort of light CBAs for just labor. But, obviously, whenever there's an opportunity to pair that with a CBA, working on that type of stuff.
Awesome.
And I'll pass it to Jenny.
Hello, everyone. I am Penn Future's campaign manager in Erie. I do a lot of water-based policy work. I'm here to take notes, and I'm also recording, but I did want to just say that working in Erie, I am from a community where there is a lot of resistance and historic reluctance to engage in the conversation around CBAs. My work right now most closely aligns with trying to bring federal investment to Erie and understanding the Biden administration's priority for CBAs in these conversations. I'm interested in learning more.
Shannon, why don't you go next? Everyone's gonna be afraid of butchering your name.
My name is Shannon. I'm a recent graduate from Oberlin College, which is in Northeast Ohio. I am also a summer intern at Reimagine Appalachia, and this is really out of my depth, so I'm excited to learn and kind of take a deep dive.
Kathy, last but not least, from our faith team.
Oh, thanks for that. Hi, Kathy Robofski. I've worn many hats over the years. One of them is not being a lawyer, so I appreciate anything I can learn from Julian. I'm an architect, sustainability manager, and most recently development and program manager with Pennsylvania Interfaith Power and Light. So we're looking to build community benefits agreements, to build coalitions within communities as we apply for some of these grants that are coming down the pike. So I'd like to learn all the pitfalls primarily and some of the processes so we can be successful in our work. And we'll probably have to hire an attorney, but just so we know the bottom line. Thanks.
Oh, I wonder if Julian's frozen.
Yeah,
But
he just-
I think that was a good tee up because that was my goal for this session. Like, I think we all need to know some of the pitfalls. Like, there's some things we want to be able to do but can't do. And is it Judy?
Hey, Judy. Yeah,
Judy.
Julie.
Maybe since we temporarily lost.
Yeah, he told me his computer is resetting, so he'll be back in a second.
Yeah. Do you want to
Share a little bit of something we've been working on recently. A community organization in St. Louis called We Power reached out to us earlier this year. They're interested in launching a campaign for a community benefits policy in their city, which would require developers to provide some minimum community benefits and then also to increase transparency around what their proposal is and share what other community benefits they're thinking about. And the goal of that increased transparency is for community groups to then have more information so they can then start thinking about a community benefits agreement. Because a lot of times the developers are just interfacing with the city or the county, and there's really not enough information going out to community. So we've been looking at different models. Not that many cities have done this. Detroit I think was the first one. And then Julian worked on one in Richmond, California. And so the policy we're considering for St. Louis is probably going to be more like the Richmond policy, which has like minimum community benefits required. And then St. Petersburg, Florida is another one. And then Cleveland, Ohio is considering it as well. So in addition to actual like contracts, which are, CBAs or contracts, there's also a way of going about, having a community benefits policy that requires some minimum benefits. He's back.
Got it. Sorry, I have absolutely no idea what happened there. I didn't even touch my computer. The battery's fine, and it just shut down and gave me a black screen while Kathy was talking. So sorry I missed the end of your intro, Kathy. But I think I'm back set up with everything proper here. Okay, it sounds like so Elizabeth, you're the only lawyer or soon-to-be lawyer here right now. Is that right? Did I get that?
Technically, I'm a lawyer, but that's not why I'm here.
Okay.
I guess.
And then it's Judy, of course, but she gets to hear from me plenty of times. So that's good for me to know, because when we go through the slides, it can be about working with lawyers, and I can emphasize the aspects of just how coalitions work and are structured. That'll hopefully be useful for everybody. So should I just jump in on the share screen? And everybody should just jump in literally anytime with questions or whatever. So I'm not going to be able to see you guys because I'm going to look at the slides. So I'm going to try to do these fairly fast and let us have a conversation. But please jump in and have a conversation during it. Yeah.
I was just gonna say, and one thing I think when we lost you, we talked a little bit about like wanting to know some of the pitfalls, things that we might want to do but can't do.
For sure. Okay, I'll keep that in mind. And as I say, all of you should feel free to jump in and interrupt me at any time. So otherwise I'm just staring at my slides and talking at them. Okay. Here we go. All right, so I don't want to spend much time on this because this is covering all the stuff that it sounds like you hit a bunch with Joanna and probably others the other day about coalition advocacy. But usually for a coalition, you have some individuals at a local level and then lots of organizational members. You always, I think, have varying degrees of sophistication among the members of the coalition. There's often a mix of labor and community representatives. This last bullet and the sort of things under there to me, that's like every time I do a conversation about this, no matter how legally oriented it's supposed to be, we get back to the question of what makes for a successful coalition. So I know you talked some about these things, but this is just the list that I think Lane, one of the leading organizations out of the Partnership for Working Families, now Power Switch Action, put together like literally 20 years ago. I think I'm the only person who still uses this list of 7. It's like they branded it like the 7 capacities of highly effective campaigns. So I don't think we want to spend too much time on these things right now, but we can talk more about the organizing capacity, the research, political advocacy, media, fundraising, legal, and internal leadership / like keeping things organized, keeping the trains running for the coalition. We could talk about any of that stuff. I think the important thing here is that you don't need one organization to have all those things. That's like the campaign or the coalition as a whole probably should have all those things. I also would emphasize, I don't know how it is in Erie, but even when but in California, even when it's a very popular project that everyone is pretty sure is going to get approved, if a coalition brings all these capacities and really presses the decision makers and the public and the developer around these things, they will get some traction and be able to improve the project, even if it is going to go forward. All right, so let's talk about the organizational structures for these coalitions. So the most common structure that I've seen, and certainly the structure that has been used, is in the successful CBA campaigns that I've been involved with, almost always, is no structure, no formal organization. I guess I should say no legal organization for the coalition. So you might have something in writing laying out the expectations and what you're trying to do with the coalition. Lots of times you have these sort of coalitions form around a particular project, like the Coalition for Fair Stadium Development of West End Cincinnati or something. But you're not setting up a legal entity with a board of directors and formal membership agreements and voting rights and all that stuff. All that stuff just kind of doesn't work, in my opinion, and it's certainly not necessary because, as I say, most of the large CBA wins that I've seen, you didn't have anything like that, and I'm really not sure what it adds. Right, like all the leverage points I mentioned on the prior slide none of those depend on the coalition having a legal structure, and really nobody even asks about the legal structure until you get to the CBA execution stage, when it's like, who's a party to the CBA? So you'll be happy if you get to that point. But on that point, it's still not very helpful to have a formal legal structure for the coalition, because usually you're going to want the individual organizations rather than the coalition to be parties to the CBA. And the developer is going to want those things, going to want the individual group signing also. So I think I have a little more material on that because you know, that's a legal point. But I guess the takeaway here is that for me is that unnecessary formalization is a major pitfall for coalitions, and I've seen them spend a lot of time trying to, you know, work out how they would handle complicated hypothetical conflicts of interest, how they would handle hypothetical situations where, you know, there are voting disputes, and, you know, none of that I think is really very helpful. I'm not really monitoring the chat. I don't know if I should be, but again, just please jump in if you've got something. Okay, so if you're talking about the coalition negotiating CBA, you've got, I think you guys have covered pretty well these basic concepts here, that you've got a proposed project, you've got this bargain where if the project goes forward, the developer is providing these benefits, and the coalition is going to support the project or at least not oppose it. If you want, we can talk more about sort of the options there and how those dynamics play out around project support, because that can be a little sensitive. But the important thing is that the result is a contract. So I think Joanna was very clear about that. So the thing with contracts is they can only be enforced by the parties to that contract for the most part, and that everyone who signs it is going to be bound by that contract to some degree. So this is the point when these questions about what is the structure of our coalition, who is really acting here at the end of the day from a legal perspective, really comes to the forefront. So I guess this is what you call a first world problem, because it means you've successfully got the developer to the table with your great campaign. You've successfully got to a deal that, you know, most of your coalition members are happy with. We can talk about how things play out when, you know, most are happy and some are not. But from the legal perspective, at the end of the day, and I guess really for everybody's perspective, it's absolutely important to know who is going to be signing this thing and thus required to support the project or not oppose it, and then who can enforce it over time. So this is a, you know, absolutely central question and an ongoing tension or even limitation of the CBA tool, is that, you know, most contracts have ongoing performance by both sides, right? Like you know, you stop paying your cable bill, they stop providing you cable, they stop providing you cable, you stop paying the bill. So there's always this sort of back and forth accountability. But with a CBA, everything the developer cares about, we're doing at the front end, right? Which is not opposing the approval of their project. Whereas all the stuff that they have to do over a period of decades, possibly. And it's not even going to be them. It's going to be successors to them. So other developers who come in, other landowners, operators of space within the project, etc. And at that point, none of those parties need anything from the coalition. So all that is sort of binding them to the original CBA deal is this contract language, right? And that language getting incorporated into leases and sales agreements and so forth over time. So it's very challenging from a legal end. So you've got to have a strong approach. You probably want multiple ways to enforce it if you can. And the strongest approach is to have the individual coalition organizations actually signing the CBA and becoming parties to it. Any questions about that before we keep going?
What would you describe as a standard enforcement mechanism?
So because it's a contract, the normal sort of default way that should be thought of for the enforcement mechanism is that a party can haul another party into court if the other party breaches the contract, right? I think that's your starting point. There is a question of whether it's better to have arbitration rather than litigation as your remedy. So that's something that can be worked through. Then there's ways that sort of deviate from that standard mechanism, which I think is the strongest approach, you can deviate from it. The developers will sometimes propose having, like, you have to have a vote of the coalition members or a majority of the coalition members in favor of an enforcement action before that enforcement action can proceed. So that obviously makes enforcement a little more challenging, but you can understand why they would want that. And then sometimes there are very complicated discussions about the possibility of like a CBA oversight board or a CBA monitoring body that could get set up through the CBA and have representatives of the developer, representatives of the community-based organizations, maybe representatives of the public on it. And my view is that that kind of body, if it's like a problem-solving and transparency body, it's a value add. But if it's a body that has to take action in order to enforce, for the CBA to be enforceable, then I think it is it whittles away at the enforceability of the CBA. It makes enforcement more challenging. So as Joanna said in the last session, you know, if you stick with the basics, which is that you're party to the contract, another party breaches, you can file suit, then, you know, you don't actually usually have to file suit, right? If it's a clear breach of the contract. And then one other question about how are they enforced? Most of the CBAs that I've worked on, what we've negotiated into the CBA is what the lawyers call injunctive relief, meaning a court or an arbitrator could order a party to do something. And that's generally considered more valuable, you know, by coalitions, community representatives, than money damages, right? Like, so if they're just like blowing off their local hire obligations, you want them to actually hire people from the community the development is in. You don't want to have some arbitrator saying, well, how is, you know, the West End Job Center damaged by the Gap not hiring local people, assigning a dollar value, and then having payment there. So usually the CBAs that I've worked on, we have a preference for injunctive relief as opposed to the possibility of damages, which is sort of the default if you don't think that through.
Oh, that makes a lot of sense.
Cool. Anything else about that enforceability aspect or this question of who signs the CBA? I'll note these questions really come up all along during CBA negotiations as soon as you get into starting to think through the CBA itself. And once you're past the overall, like, what are our goals, and you're at the table with the developer, they're going to ask, who is signing this and what are they committing to?
And Julian, you mentioned this, and maybe you'll get into this later, but how the developer then at least, you know, sells the land and then it gets leased out. And I know, you know, you have talked in the past about how to like incorporate in the community benefit agreement, like instructions for those leases to also incorporate community benefit provisions. Can you talk a little?
Yeah, I have a lot of thoughts on that. But it gets into very technical lawyering stuff that is the most challenging aspect of the legal provisions of the CBA, right? Because as I said, if the party that comes in and is leasing out the developer, a portion of the property from the original developer, if they don't sign on to the CBA, you're completely out of luck, right? And you don't really have control or total transparency about these negotiations the developer is doing about other parties' successors coming into the project. So, I think when I first started doing these, I had this notion that, there was some standard legal language that like the big firm real estate lawyers knew about how to make sure that successors were bound by deals. But in fact, that's not the case. So I ended up, after the first few of these I did, talking with a lot of lawyers, trying to find out like, what's the magic way that those fancy lawyers know? And there is no magic way. And this issue of successor liability, when another party comes in to a deal that, a couple parties negotiated around originally, is like one of the main sources of litigation in the business world and in the business real estate world. So there's no perfect way to write it. So, you know, when I'm briefing clients before they sign these things, you know, I'll be like, look, you know, can I swear to you that we've actually locked down every actor who's going to come into this project over the next 20 years? No, but you know, we do our best in the CBA to say, hey, when you're selling off a piece of the property or you're leasing it out or you're bringing an operator in, you have to notify us. You have to include the CBA as an attachment to whatever contract you're using to bring that party in. And they have to sign something, and we have to be provided with that piece of paper indicating that they're going to you know, comply with terms of the CBA, and that we can enforce the CBA against them if they breach. Does that always happen? No, right? So, you know, that's where the transparency and these sort of ongoing meetings and involvement in the project becomes really important, because you have to have a relationship with the developer and ask them questions about what's going on with the project and who's being brought in, so that you can press them to include the CBA requirements. So it's a very challenging aspect of this thing, and I wish I had a perfect answer or perfect legal language.
Yeah, well, and it just reinforces the idea of having an ongoing sort of community benefit advisory board that's monitoring this stuff.
Exactly, 100%. All right, let me get through a few more of these slides, give us time to talk. All right, these are attorney duties. So we can sort of flip these and think about if you're in a coalition, like working with an attorney. So this is what you should expect of your attorney. There should be absolute clarity on who the attorney is representing. Maybe this seems super obvious. If I could see you, I'd ask for a show of hands. Does this seem super obvious? But it has happened multiple times in CBA negotiations that the developer will provide an attorney, quote unquote, for the coalition. Coalition maybe doesn't have money for their own attorney. And then this attorney provided by the developer is, quote, helping them, unquote, but they're not complying with these basics of professional responsibility. And it's not even clear necessarily whether they are the lawyer for the coalition or merely the developer's lawyer who claims to be helping the coalition. Seems super obvious, but you know, it does happen. And I think Joanna referred to a situation like that this morning when she said, you know, you have to make sure you have a written agreement with a lawyer, even if it's referred by the developer, et cetera. So the lawyer should be able to say who they are representing, all the parties they're representing related to the matter, if they're trying to represent multiple parties. They have a duty of confidentiality to you, so they can't share whatever information you're telling them. Duty of loyalty is very important, and that basically means your lawyer can't have their own agenda related to the client that affects any aspect of their work for you. So so lawyers get to pick their clients, right? But once you've picked a client as a lawyer, you have an absolute duty on that matter to be advancing their interests and no one else's. And if you don't feel like you can do that due to your personal views about the project or other professional relationships you have, or another client in the matter, you have to notify everybody, and you kind of can't do your job unless you get written consent from everybody. So these rules are for the protection of the client and the lawyer. The lawyers have a duty to be clear with anybody if there's any reason to think that someone who they're not representing thinks that that lawyer is representing them. So I remember in law school hearing about this rule in professional responsibility class and thinking, well, that seems random and weird. Like, when would that come up? But it comes up all the time in CBA negotiations, right? Certainly if a developer's lawyer is participating at all and talking with coalition members, it comes up. But even as a lawyer for one member of the coalition, the other coalition members may think that you're representing them as well. And, you know, coalition members are not always, it's in writing who the client is, who is authorized to instruct me as a lawyer, and notice and consent if I am representing multiple parties in the matter. So any questions about that set of lawyer responsibilities and how they play out in CBA negotiations? All right. A little more on this. This may be a little in the weeds for lawyer stuff, but the lawyers can represent the legal organization. Legal organization is a coalition member. This happens a lot when you've got like a legal aid society or someone who wants to help, but doesn't get into representing an attorney as an attorney, but rather itself becomes a member of the coalition. So it would be like the coalition would be the various community groups, and Legal Aid of Cincinnati might be also a coalition member. So that's a totally valid approach, but again, you have to be clear that you're not the lawyer. You're not the lawyer for them, so you can express your own position as an organization, but you don't take direction from the other coalition members.
And I suspect that's the role Fair Shake. They have a whole team of lawyers that might be doing work in this area, but probably as a coalition.
That's totally fine. That's how Shea Judy worked at a place called Public Advocates in the Bay Area, which often sort of acted and was like, here's Public Advocates' position regarding this matter. And the one thing, and you can bring a legal skill set to the coalition, but you don't have these duties of confidentiality. You don't have these duties of loyalty. You do have a duty to make sure that everybody knows that you're not their lawyer, right? That you're bringing your own views. You can, withdraw from the coalition at any time. You don't have attorney-client privilege on your communications, etc.
This is John here from Fair Shake. I just wanted to say we do not ever join the coalitions and become members. If anything, we just sit on the side and try to advise or guide and just be of help as opposed to being a member.
I see. So it's not a coalition member, but it's also not legal representation. It's like TA provision, I would describe that as. Technical assistance provider.
Yeah, I think that's probably better. It's more of an educational role or informational role.
Yeah. Also totally valuable, way to assist a coalition like this. But if they get into an actual CBA negotiation, they're going to want a lawyer, and they're going to say, "Wait, can you do this for us?" I would imagine.
Right, and that would change things. Obviously, we would take a different role at that point.
For sure. Yeah, nothing wrong with that, as long as, to me, the important thing is that everybody's clear about, everybody's role. And I've got one more slide at the end about, why it's especially important for lawyers to be clear about their role. So I don't think we need to go through these other options of how lawyers work. I think we've got the takeaways there.
Yeah, I think you said that.
Yeah, same here with representing multiple clients. You can have a lawyer representing multiple clients. It's pretty routine in CBA negotiations when coalitions all want, the members all want representations. But, it should be done in writing and should be very clear to everybody. That's always my approach, right? Let's see. I think I have 2 slides left. Hold on, let me check. Yeah, 2 slides left. So this is a slide about how the negotiations can actually be structured. So I think I'm just going to sort of introduce this topic, and if you guys want in the Q&A, we can come back and talk more about this. How many reps you have at the table. Here's to the last point, coalition members versus TA or lawyers at the table. Whoops. How the coalition makes decisions between negotiations, how attorneys are involved in negotiations. All of this goes to how the coalition works and how attorneys work with the coalition members when you're in active contract negotiations for a CBA. So we can get into that. Yeah, Amanda?
Yeah, no, this comes up a lot, and it came up this morning, but the idea, and it's, I think, particularly prevalent now with the Biden administration Good Jobs Initiative, that specific community organizations or members can be picked off from a coalition and sort of you know, they get what they want, and then the developer says, now we have community support. And how do you prevent that as part of the committee structure, or
You
how
mean
you
the sort of
organize?
peeling off of a group?
Peeling off members of a group to say you have community support, but then you don't end up getting what, you know, the coalition itself.
Yeah, I think that goes all the way back to slide 1 here, which is the coalition members having clear expectations with each other that they shouldn't be doing that. No side negotiations. If you go cut a deal, you're screwing us over. I mean, it may get pretty hairy at the end of a negotiation because, you know, the developer's not going to put something on the table of equal value to every coalition member. So there's always going to be some coalition members that are like, hey, everybody else got the basics that they were asking for and we kind of got screwed. Why would we sign this thing at this point? So then that has to get worked out. But that's different than a group sort of saying they're part of the coalition, monitoring it, trying to shape the coalition asks, while they're also sort of about to cut a side deal, because every side deal, as you note, makes it easier for the developer to get their project through.
Yeah. And we're seeing that now, like we're having, you know, everyone's now that, and I'm sure you know this, with the DOE sort of requiring some kind of community benefit plan. Like the developers of projects have to have these things in order to get DOE funding, when they're like coming to folks like us saying, sign on to our project and we'll give you whatever you want. But they won't even show you, you know, but we can't show you what's in the project. We just need you to send us a letter of support.
Yeah. Well, I mean, these are negotiations, right? That's where you got to stand your ground. You've got to, you know, not be a pushover. You got to be consistent with your ask. You've got to explain the rationale for them. You have to, you know, be talking to other people and not just the developer. Yeah. So anyway, okay, let me hit the last, so all of this, again, if you're really in negotiations, these kind of structure questions come up, which are very important to the negotiations being functional. The last thing I wanted to say something about is how you maintain credibility as an attorney who's not from the communities that you're working in. You're not a coalition member. You have this special role. So this could be thought of as what you should look for in your attorney, right? So I think in those cases, the rules of professional responsibility are actually really, you know, which were developed generally for the legal profession, are really valuable. So that's a lot of the rules I already talked about duty of loyalty, avoiding conflicts of interest, including informal conflicts. Clarity around roles, I think, is super important, and I really can't stress this enough, like how much this has shaped how I do work, is being very clear when I'm working with clients about when I'm giving them like a legal recommendation or a piece of advice or an explanation, and when it's more like non-legal recommendations or advice. And so, you know, I think your main job is the legal aspect, right? That's why you're a lawyer. That's why you're being brought in. That's why you have this special rules about how you work. But most clients are kind of, especially when you're involved with the project deeply and they have some level of trust with you and you've done these kind of things before, they want some non-legal recommendations. Like, do you think this is a good offer? How do you think we should respond? Should we go to the city council and complain about this thing? And I don't think there's any problem doing that, but you have to keep that stuff, you know, to when you're asked about it, and it needs to be signposted, right? So if you feel like you've brought in a lawyer and they're going way beyond their legal role and they're just sort of freestyling and giving lots of advice that, you know, isn't legal, but is more political or whatever, unless you've got a really heavy trust level, you know, you should be a little skeptical, or you should ask, be always willing to clarify, is that a legal opinion, or is that, you know, just a general political assessment or something like that? So, and I think maintaining that line is important to the power dynamics, right? You're coming in, you're a professional, You're probably a smooth talker. You probably have some experience in the area. You've got this window into aspects of the project that other people probably don't understand. And that should be, that's important. And without whittling down the value of that, you need to be watching out for the power dynamics and not have undue influence over the non-legal aspects of it, where you don't have any special expertise about the politics. You probably know less than they do about it. Lawyers are also, not known for being underconfident, right? So, you've really got to be careful about what kind of advice you're giving and signposting it when it's not legal advice. It's just, hey, it's my take as another person involved. So take that for what you will. And being very careful and consistent about that, I feel like, is really important.
So quick question. So in a sense, you're saying that that's not under your professional liability, so you can't be sued for non-legal advice because it's just kind of opinion based. It's not factual or.
I actually wasn't even thinking about the legal liability. I was thinking only about maintaining credibility and what is a legitimate approach as a lawyer.
Yeah, but you have to think about that too.
Yeah, I guess so. Yeah, I guess that's right. Yeah, I guess you can't really be sued if you're like, I think they'll accept this deal, or I think there's no way they could, accept that, and you need to water it down. Yeah, I don't know. I guess I hadn't really thought about how likely it is that you're going to get sued over like going beyond your boundaries there. But I think there's just overwhelmingly important rules, principles that I find important about why you've got to maintain those boundaries and be very clear that don't even get into like, are they going to sue you?
And the client should be sure that they understand the difference, so they're not asking you those questions. Like, why waste your time? Like that, they need to decide if it's a good offer. You're just there to provide them legal expertise, not to analyze and interpret that for them.
Yeah, and they may want your opinion, and it's fine to give your opinion if they ask for it, and if you are clear that it's not a legal opinion. Right? It's just, hey, you asked, my take is blah, blah, blah. Like, I think that's totally fine. And I think you'd probably be doing a little less than your maximum value to the client if you were like, I will never say a word that's not strictly legal. I think the law goes a little broader than that. But I think it's on you as the lawyer to signpost that stuff. And if you're a client and you feel like your lawyer is giving this general melange of legal and non-legal advice, with their role that has some inherent power behind it, especially if you're not sure that they don't have other things they're sort of pushing you toward, under that first bullet, duty of loyalty. I think that's when your antenna should go up and you should ask for clarity about the basis of a recommendation.
Makes sense. Thank you.
Yeah. All right.
I wonder if you could give us a few thoughts on like those big pitfalls we talked about. Like, what do things want to do that they can't do legally?
Well, I don't, I'm not sure. I think I hit a few of the pitfalls of working with lawyers already in the slides. Do you have some like example?
Yeah, no, I'm thinking specifically about like outcomes or what people want when they come to the table. And I'm thinking specifically like, people want to say things like 20% of the jobs go to Black workers. But there's like that's like Supreme Court legal sort of no, but there's ways to get around it.
Well, so there definitely are, but even just a race-based classification, as the courts would put it, in a private CBA, you have more ability to do that than the government does, right? All that Supreme Court jurisprudence about that relates to the public sector, what a city can do, what a transit district can do, or whatever. But in a private CBA, you have more flexibility there. So I look at that as an advantage of CBAs. But if legally or politically that feels risky or provocative and you've got a good workaround, in California, we're very experienced at workarounds on that, right?
Yeah.
We have laws that mean that we have to develop those approaches. Judy's been doing a ton of work on that. So we do local hire, disadvantage hire. you know, a lot of times that's a really good fit with, you know, the soccer stadiums in a neighborhood. And, you know, people are usually, if people are like, okay, we're going to do a special job training program and pipeline into apprenticeship programs and into jobs on the construction of the soccer stadium for people who live right around there. I mean, that's a pretty compelling policy goal, you know, even if, you know, racial equity is also a policy goal. So there's enough overlap there that sometimes that's the way people choose to
No,
go.
I think we could probably spend the rest of our minutes together. You see Jim nodding his head too. Like we have in Kentucky a ban on use of project labor agreements. And does that sort of apply here? We're thinking, is CBA a workaround for that? Do you know? I know that there's a court ruling specifically around this, and I don't know if it's just that the state can't require one, but you can use one in
A CBA or a
contract.
PLA?
Well, like, can a CBA said you need to use a PLA?
I guess we'd be getting really into the weeds, and I'd look to James's lawyers for you know what agreements can do related to labor relations. That's a real can of worms or something like that. But you know, it is pretty common that you have like labor and community reps advocating together around a project, but then what is actually agreed to is in like some are in the CBA document and some things are like in a labor peace agreement or card check agreement that's adjacent, sort of parallel at the end of the day. So unified campaign, separate contracts that arise out of it at the end is a standard model.
The short answer is private organizations can enter into PLAs with labor unions. And it's typically the laws in certain states, say Kentucky, for example, that have a ban on PLAs are for public institutions entering into PLAs. And in fact, I don't think the state of Kentucky, for instance, would be able to ban PLAs between two private entities. And until the Supreme Court rules them unconstitutional, which let's hope that doesn't happen anytime soon, PLAs are pretty established at this point.
Could you have, I know the labor issue is really complicated, and there's a project in Miami that was really caught by journalists in not providing the number of people from a certain zip code area around the facility as workers on the site. And then the developer argued, well, there weren't enough people in that area. So, I mean, I guess you got to think about who's there too, and what's the availability, but can you include in your CBA the ability to hire, or the requirement that the developer hire or the community organizations hire an independent reviewer who monitors and tracks throughout the entire project, like who's working there and who's not and where are they from? I mean, no developer is going to track that, right? I mean, that's like a full-time job. So I would think, when you have to hire someone outside of the coalition who would be independent of both parties to monitor that?
Well, you don't really want to outsource the monitoring completely as a coalition rep, right? So you want to be sure that there's a legally enforceable right in the CBA to make the project participants provide information that enables monitoring and enforcement if necessary, right? So there's a bunch of different strategies for that. I find it hard to negotiate the particulars in that because, you know, you start talking about monthly reports to third parties, you know, the developers are like, oh my God, we're never going to be able to lease out our project if everyone who comes in knows they're going to have to do all this stuff. So I guess I've ended up landing more on very general statements that the project participants are going to be required to provide information necessary to determine compliance. It's very hard for them to push back on the notion that we should be able to get information to find out what's happening at the really abstract level, but very easy for them to push back on monthly reports that no one's going to look at and will cause us to sue their contractors or whatever. So I'm putting in the chat, I just put in the chat some of my, hang on, or I'm adding more stuff. Attorneys or campaigns. Unfortunately, I have another Zoom starting in 1 minute that I'm the host for, so I'm going to have to jump off for that. Judy's been working with me a ton, and has a lot of knowledge about CBA policy development from the St. Louis work that she was probably telling you about when I had the computer crash. But I really appreciate the interest and the chance to come talk with you guys. And any of you guys should feel free to reach out for help with your lawyers, or if there's other lawyers interested in working on this, or you, Elizabeth, just for career paths and this stuff, or ways to get support for local lawyers doing this. It's really exciting.
Thank you.
Thanks,
you so
everybody.
much.
Take care.
Yeah, you'll hear from us again.
He was great.
Yeah, love him. I think there's a lot more we can learn from him, so we might have to bring him back.
Well, we might have to hire him.
Yeah, but I was totally just thinking, I wonder how much it costs to have him on retainer.
Right.
All right, let's go.
Really helpful. So are we leaving break room?
Yeah, people are leaving the breakout room.
To stay for sure.
We understand. We understand.
We were just talking about how we might have to keep Julian on retainer.
Mm-hmm. Welcome, everybody. I see everybody's coming back in. I think we're pretty close. I'm looking at my...
I see our favorite mayor.
We have a lot of favorite
I
mayors.
was gonna say it's actually.
I
something
know,
else.
but like Brittany.
I was getting some text messages about how wonderful your presentation was, Brittany. So I think we'll have to have folks.
Hey, thank you all. This is a huge honor for me. Thank you.
I think the gang's all here. So for the next, we have a few more minutes together today. I want to take maybe about 2 minutes each to hear quick reflections from the breakout groups, thinking about what were some exciting things that were shared, or pieces that you are excited to see built upon or to see growing. I'll go ahead and go through the order of the options, and if any of our facilitators do have to jump, I know how busy everyone is, so no worries, we'll figure it out. But I don't know if Joanne or Megan could share a few highlights from option 1.
Sure. I'll get started, and Joanne and anybody else, please feel free to chime in. So in our group, we were talking about authentic relationship building and really using that to center ongoing visioning and engagement activities to help build that diverse coalition. And so we shared a number of tools just to help groups think proactively about how they can build up that diverse coalition and grow those authentic relationships, as well as the amazing visioning example that Reimagine Beaver has started and continues to, be part of this ongoing process of using visioning to engage and build relationships, which leads to a stronger vision and more relationships. So that was a lot of the things that we talked about in group 1.
Yeah, I'll just add, since it was about relationship building, we spent some opening time on direct sharing. And I really appreciate the people that joined and shared their stories with us and were willing to participate. Everybody spoke. Everybody either had a contribution or question. So I really appreciate, creating that kind of relationship building.
Thank you. Wonderful. So option 2, I'm not sure I see you or Dan. I know both of you were in that workshop, and that's okay if y'all had to jump. I'll give it a second for someone to hop off mute, but that group was focused on conflict resolution and difficult conversations. So I'm going to move to the next spot, and if someone wants to sort of raise your hand to speak onto that, feel free to. So option number 3, Emily, I'm so glad you were able to join us. Do you want to share a little bit about the research and education to empower communities?
Yes, I mean, we just talked about the basics of researching with very little information and just trying to use what you have to gather additional information, and just, it can seem like a rabbit hole at times, but that is kind of the process in early development projects. And then relying on your government resources that are involved in development, whether that be your local planning commission or the regional economic development group in your state, or your state economic development group, or a national economic development group like the Appalachia Regional Commission. And those sources are very helpful to try to get information on early developments, because you're not going to have permits started yet, anything like that. So you really have to use as many resources as you can, whether that be word of mouth, government records, community, insights. So just getting creative and following through, and then continuing to follow through as the process develops, because since we're early on, it could easily take years, and remembering to go back and continue to follow up and stay knowledgeable and involved in the process.
Thank you, Emily. And should Judy, on option 4, to talk a little bit about how that discussion went?
Sure. Yeah, we talked a bit about the relationship between an attorney representing a coalition and a community benefits negotiation process. We talked about how it's important for community groups in the coalition to have clear roles and commitments to each other written in writing before they start negotiating with the developer, to make sure that no one's having like side negotiations with the developer, and that they're all, coming together on a united front. So we talked about that. We talked a little bit about, how the attorney, can't make any decisions for the coalition. The attorney will have to, make sure that they're presenting all of the options from the developer to the community groups, to the coalition, and the coalition has to sign off on any final decisions. Yeah, and then what else? If anyone else from the group wants to chime in, those were some of my highlights though from the conversation.
No, I think that was well said. I would just add like the importance of that community benefit coalition to stay together over the long haul, to monitor and make sure like the things that were promised are happening, and be at the ready to do something together, if that in fact is not the case.
That's great. So many incredible conversations that I can just see turning into incredible work. And so option 5 was opening up communities that are resistant to new ideas. I heard that was incredible. Arafeli, do you want to reflect a little?
Yeah, definitely. So we heard first in our breakout room from Mayor Reno from Sharpsburg, Pennsylvania, about the projects that they're working on to vision and implement their vision for Sharpsburg's future. And we spoke about that within the context of like difficult community conversations and what it means to be a town that's located outside of the big metropolitan area of Pittsburgh, and dealing with some of the same issues and dealing with regional issues as well. And how you move forward with kind of like a mixed political ideology. And in particular, we talked about a couple of examples of ways to move forward from like resistance within communities. We talked about the importance, of course, of listening, and in particular, Brittany spoke about reframing listening around like what are the issues into what folks do want, into like that more visioning perspective, paying attention to what resources the community does have. So reframe